Is there a seconder for the motion?
I second the motion.
Thank you, Member for Charlton. I call the honourable member for Dobell.
And thank you, Madam Deputy Speaker, and I thank the member for Indi for bringing this motion to the House. My support for the victims of domestic violence is well documented both in this House and in my local community on the Central Coast. And many within this place and within my community would know that I am a strong advocate for the need for the government and the legal system to have policies and procedures in place that are responsive to the need of the victim. And it's horrifying to acknowledge that intimate partner violence is the top risk factor for death, disability and illness in women aged 15 to 44. This blight on our community can and must be acted upon and cease immediately. And there is nothing more confronting than having to interact with a victim's perpetrator in a formal courtroom setting. And in my opinion, this is a continuation of abusive relationship. The strength and courage found by victims of an abusive relationship to leave is incomprehensible, and as much support as possible needs to be provided to ensure the move they have made and the follow-on outcomes are not made any more traumatic. For an abuser to have the opportunity to cross-examine their victim in a formal court setting is unacceptable. And this is why Commonwealth, state and territory governments worked with the community to develop a 12-year national plan to reduce violence against women and their children. The plan includes within its vision Australian women and their children to live free from violence in safe communities, and that a significant and sustained reduction in violence against women and their children is actioned. The second action plan of the National Plan to Reduce Violence Against Women and Their Children was launched on Friday, the 27th of June. And one of the main outcomes of this plan is to drive continuous improvement in systems across the Commonwealth and the state and territory governments through reviewing domestic and family violence-related policies. Within the plan are actions to improve information sharing across court processes. Commonwealth, state and territory governments are continuing to explore and implement methods to improve collaboration and information sharing between court processes to achieve the best outcomes possible for victims. The plan also involves initiatives that concentrate on the impact of victim-focused court practice reforms. And I strongly support the call within this motion to amend family law legislation to ensure that in a situation of family violence, an unrepresented litigant alleged or known to have perpetrated violence is prevented from and legally prohibited from directly cross-examining a victim. Improving efficiency and the relevance of the justice system in response to domestic violence is an important aspect of the new reforms that form part of the national plan. And I acknowledge the efforts on behalf of the states and territories in recognising that this is a problematic area and that solutions are being implemented to combat this issue. With state modifications complemented by Commonwealth government changes, it will soon be evident the issue of intimidation and confrontation in courtrooms as a result of the cross-examination of a witness by a perpetrator has been taken seriously and remedied. Key initiatives such as specialist court responses, services and projects will help complement and support victims as they go through this difficult time. And I'm particularly supportive of the need for specialist services for child witnesses. The support of child witnesses in court proceedings is paramount, and it is pleasing to see that under Priority 3 of the Plan, Action 16, specifically reiterates building support for children who have experienced, witnessed or been exposed to violence. National Priority 4 of the Plan specifically addresses improving perpetrator interventions, and this section reiterates that systems including police, justice, corrections and community services need to work together to increase the effectiveness of perpetrator interventions. And it is important that this applies to all victims in the courtroom setting as well. Preventing and reducing violence against women and children requires strong legislation that is efficiently administered and holds perpetrators to account. We can't provide an accused person with the opportunity to examine a victim in a court case. The implementation of strong legislation is a means of preventing this from occurring. Violence against women and children can be defined in many different ways within each state and territory, having their own definition under their respective legislation. Now, I am proud to be part of a government which takes the eradication of violence against women and children, and in some cases men, seriously. And this is demonstrated in the recent announcements of over $100 million to fight the issue of domestic violence. And as part of this announcement, I will be campaigning to have legal assistance service provider allocated to the Central Coast in the coming year, and I commend everyone who is fighting against domestic and family violence.
Thank you, Member for Dobell. The question is that the motion be agreed to. I call the honourable member for Moreton.
Thank you, Deputy Speaker, and I rise to speak on the motion put forward by the member for Indi and commend her for her interest and initiative in this area. Domestic violence is an enormous problem in this country and around the world. In Australia this year, we've seen at least one woman die every week at the hands of a current or former partner, and we've seen some particularly troubling scenes in Queensland. 1 woman in 3 experiences physical violence, 1 woman in 5 experiences sexual violence, and men are not immune from experiencing this horrible scourge. Be they heterosexual or GLBTIQ, nobody is invulnerable, whether they even perhaps it's horrible to say, but the young students from FCJ College at Benalla that are here hearing the member for Indi's motion be debated. A Family Law Council report released in August identifies data suggesting that over 60% of parents experience pre-separation violence, and almost 20% of parents report that they are concerned for the safety of themselves or their children as a result of ongoing contact with the other parent. This year I've spoken to many family lawyers, community legal centres and litigants from Cairns to Perth, Adelaide, Sydney, Melbourne. And in Brisbane, obviously. I'm constantly being told of the ability of perpetrators of domestic and family violence to continue the abuse through the legal process. This can take many forms, including using delaying tactics, not providing disclosure as required by the court and not turning up at court as required, not cooperating with any attempts at settlement, forcing both parties into the court process, a process which is intimidating for anyone, but even more so for someone who is fleeing family violence, and attempting to use the process of cross-examination as another weapon to inflict pain, as detailed in the member for Indi's motion. Cross-examination is and has always been a part of the court process in contested trials, and this obviously can be a very traumatic part of obtaining judicial guidance. I do note that cross-examination is not part of the process for interim hearings, when matters first come before the courts and decisions need to be made on a temporary basis until the trial can be heard, that is, when the facts are tested by the judiciary. In those hearings, the evidence is by way of affidavits from each party and is not tested through cross-examination. And I do note, thankfully, that most matters actually don't go on to a trial. If matters have not been resolved by the time a court can hear the trial, then it will be heard by a judge in a contested hearing and all the evidence will be tested through cross-examination. The time frame in between the interim hearing stage and a trial is getting longer and longer, with the Chief Judge of the Family Court, Diana Bright, stating in an interview on the ABC radio last week that it is now likely to be 12 months delay, a year of stasis, and a year can be an eternity for a child and even for parents. No one wants to see a victim of family violence being cross-examined by the perpetrator of that violence. The prospect of that happening is much more likely now than it was some time ago. Self-represented litigants are increasing in number in our courts. The increase in self-represented litigants is overwhelmingly due to the decrease in funding for access to justice. The Attorney-General, Senator Brandis, has shown complete contempt for access to justice by ripping $15 million from legal aid commissions in last year's budget. That cut followed $43 million of cuts in late 2013 to legal aid, to community legal centres that are already incredibly lean organisations, to Aboriginal and Torres Strait Islander legal services, and worst of all, to family violence prevention legal centres. It is vitally important that victims of family violence be represented in their family law hearings. With cuts to legal aid and legal assistance services, this is increasingly unlikely to be the case. Apart from the immense protection that representation provides in court, both legally and emotionally, representation aids the court process by ensuring that only relevant issues are aired in court and only relevant questions are put to witnesses. Court time is very, very valuable. Waiting times are increasing, not only due to the huge number of matters being listed in courts, but also due to the Attorney-General failing to replace retiring judges. There are 6 vacancies in the Federal Circuit Court and 1 in the Brisbane Family Court. The Attorney-General took 560 days to replace a judge in the Sydney Registry of the Family Court. The Chief Justice, and I know that there are also delays in Newcastle. The Chief Justice said last week that the courts will never make up the time from the delay of replacing retiring judges. With court time so precious, making the court process more efficient by providing representation for litigants would not only assist those litigants, but our entire family law system. Women who have experienced family violence should not be left to negotiate the family law system alone.
I thank the member for Moreton. The question is that the motion be agreed to, and I call the member for Newcastle.
Thank you, Deputy Speaker. And I indeed spoke earlier today on some of the implications of having a judicial system that isn't adequately resourced and staffed. And in my electorate of Newcastle, that's having really a profound impact at the moment, where we simply are not having judicial replacements appointed in a timely manner, leaving, women and children in particular, but everybody who is seeking to get parenting disputes settled in a really unsatisfactory and unacceptable kind of point of limbo. But I do thank the member for Indi for bringing this important motion before the House today, and acknowledge her strong advocacy for victims of crime and in particular victims of family violence. There is a 12-year national plan to reduce violence against women and their children in Australia. It was launched in 2010 under the former Labor government, and it brings together the efforts of governments across the nation to make a real and sustained reduction in the levels of violence against women. It was the first plan of its kind to coordinate across jurisdictions and to focus on the prevention of violence. And while there is progress being made, and I certainly welcome the government's commitment to continuing that national plan, there are indeed many areas in need where so much more work has to be done. I acknowledge the Prime Minister's recent commitment to the women's safety package to help try and stop some violence, and again put on record that this is a welcome first step, but it is just a first step. Indeed, as the motion before us really brings to light, there are just some glaring inconsistencies that currently exist across legal jurisdictions, and the accessibility of legal aid and representation in court proceedings is emerging as a very strong issue. Victims, advocacy groups and even the former Chief Justice of Family Court are on the record describing the situation as being unacceptable and in need of remedy. At the inquest into her son's death, 2015 Australian of the Year, Rosie Batty said she suffered vicarious trauma caused by dealing with the court system over several years to negotiate custody arrangements with her former partner. Every time she went to court, she would experience heightened levels of anxiety and talked about feeling desperate, alone and afraid, and trying to deal with her violent ex-partner. She represented herself in court because, in her words, the system was too expensive. The Chief Justice of the Family Court of Australia, the Honourable Diana Bryant, I note, in fact refers to this as this phenomenon of self-representation as unrepresentation, noting, from her perspective, that accurately describes the status of those people acting without legal assistance. And I also draw the House's attention to an ABC News report that was featured on the PM program back in 2013, which really looked specifically at this issue that the member for Indi is bringing to our attention today around the cross-examination of victims by their perpetrators, the perpetrators of violence. In that report, a victim described what she experienced when faced with the prospect of being cross-examined by her former partner, who allegedly raped her, when he refused to have a lawyer. She said, "I was standing outside in the foyer and I was shaking from head to toe and I couldn't breathe properly. I was hyperventilating. At that point, I could have easily just thrown myself in front of the first bus. I could not believe that he had been allowed to do this to me." Former Chief Justice of the Family Court, Alistair Nicholson, said, "The situation is unacceptable." His words were, "Not everybody realises the degree of fear that is engendered in cross-examining them in court and, in effect, putting them through the ringer. I think the effects on them are profound and it just shouldn't happen." Again, in closing, Deputy Speaker, it's clear that people, perhaps at their most vulnerable time, should indeed expect more from our justice system. It is unacceptable that victims of family violence can be, even perhaps unwittingly, re-traumatised by a process that in fact seeks justice and redress for those victims, and I commend the motion before the House.
I thank the member for Newcastle. The time allotted